Hello, welcome to How to Avoid Common Legal Pitfalls in the Entertainment Business. In this particular webinar, we are going to be discussing the entertainment contract. Okay, a little bit of background on me. I have been in full-time practice as an entertainment attorney since 2001. I handle entertainment business and legal affairs for clients such as producers, directors, financiers, etc., as well as handle their related businesses. I have executive produced 3 feature films and also conducted production legal on those. I author a column in Hollywood and Vine magazine entitled Showbiz Esquire, which really addresses issues about breaking into the business. You can find my blog at intlawpartners.com, where I discuss various issues related to entertainment law and the industry. And last, I'm a speaker on various panels discussing entertainment law and related matters. All right. What to expect from this webinar. This will be an examination of the basics of what any filmmaker or producer needs to know about avoiding the legal pitfalls and understanding basic contracts in the entertainment business. We're going to cover 5 things in this webinar. The first thing is elements needed to have a legal agreement. What do you have to have in an agreement in order for it to even be enforceable? The second thing is oral agreements. The entertainment business loves handshake deals. How do handshake deals affect you in your business and your relationships while you're doing contracts with other people? Number 3 is the role of a written agreement. What role does this play in your interactions with people you contract with and how you conduct your business under the agreement? Number 4, some standard terms in an entertainment contract. I will go through some things that you need to have in an entertainment contract that are basics and needed when you do a contract. And last, who needs a contract? Does everybody need a contract? Or what is required to even have a contract? So after that, I will be discussing then some examples to show you how in real life these examples of contracts will work. What is a contract? A contract really has 4 things that you need to have in order for it to be considered a contract. The first thing is a promise. This addresses the terms of the subject matter that you want to agree to. I promise to give you $10 and you clean my car. The next thing is an offer. What is offered? Is it merchandise? Is it goods? Is it something in the future? It could be anything, but it just has to be an offer. I offer you $10 for you to clean my car. The acceptance then is the person on the other side of the table saying, I agree, without changing the original offer. I offer you money, you clean my car. The person can't say, I accept, except I don't want to clean your car, I want to clean a motorcycle. The acceptance has to be the yes to the original offer given, or else you start the cycle all over again with a new offer and a new acceptance. And last, you need what's called consideration. This could be anything that you feel like has enough value to make the contract worthwhile for both sides. Most of the time it's money, but other times it's publicity in an entertainment field. It could be a credit in the entertainment field. But as long as you have consideration and the 3 other things, as I mentioned before, you have a contract. All right, let's put this into play with an example. Here, let's start with the promise. The promise here is, I agree to pay you to fix the front bumper on my vehicle. Next would be the offer. Here the mechanic would say, my offer is $700 for parts and labor and you get a new front bumper. If the car owner says, I accept that I will pay you $700 and I get a front bumper fixed, then we have an exact mirror of what the offer originally was and the acceptance of that original offer. And last, the consideration here is the $700 for the mechanic, and then this consideration for the car owner is, of course, the fixed bumper. So now we have all 4 elements needed and required to have a contract that can be enforceable, especially if it's in writing. Let's discuss handshake deals. I term this as part of a pitfall in the business for several reasons. The first one is I get several different inquiries from clients about, are they even enforceable? My answer is generally yes, but with regard to the entertainment business, and especially in California, there are several different contracts that are required to be in writing or they will never be enforceable. Now, I put the caveat on here that you should check your state and see if what other requirements they have for agreements being in writing. But I have listed California's here for discussion. The first one is an agreement that by its terms is not to be performed within a year from the making thereof. The next one is a special promise to answer for the debt, default, or miscarriage of another. And next, an agreement for the leasing for a period longer than 1 year. This is if, say, you rented a studio for 16 months, you would definitely need a leasing agreement in writing for it to be enforceable. Next, an agreement that by its terms is not to be performed during the lifetime of the promisor. And last, a contract, promise, undertaking, or commitment to loan money or to grant or extend credit an amount greater than $100,000. This is, say, if you wanted to take a bank loan to leverage your pre-sales on your next film. The next pitfall with regard to these handshake deals is proof. You still have to show proof that this handshake deal even existed in order for it to have it enforced. I always ask my clients, what kind of proof do you have that this existed? Is there emails? Are there witnesses? Did somebody see you make this deal? Did somebody hear you make the deal? Or did you see any performance that was based on the promise? So if somebody said, hey, can you come and do makeup, and the makeup artist actually showed up, that would show that everybody had an expectation that an agreement had been made. And last, and really what I feel is the biggest one, is costs. I have to say that it costs twice as much money in order to enforce a handshake deal that would have cost you had you put the agreement in writing to begin with. I feel that when you do an agreement in writing, you leverage and understand everybody's expectations and what they're supposed to do in the agreement, and you have a better advantage in order to be able to enforce that agreement. Okay, so what's the role of the written agreement? Well, the first thing I say is the role of the written agreement is the role of an attorney. If they save you money. If you consult an attorney at the beginning of a deal, you will likely save more in time and money than the attorney will originally cost you. This is specifically true when I say it's rather better to do it now than later. If you prevent the problem now and flush it out in discussion and negotiations, then it will save you time when you define the roles and address all the issues at the beginning of the deal, then figuring out that you have a problem and then trying to band-aid it later. Now, here the written agreement also provides clarity. It says what I do and it says what you do. And if the agreement is properly negotiated by an experienced entertainment attorney, they will know the issues that need to be addressed in that specific deal so that all the parties understand and know what they need to do and provide in the agreement. Next, having an agreement, of course, portrays a level of professionalism. You have your attorney there representing you, and you have the issues that need to be addressed in a professional manner and according to standard industry terms and comfortability between the parties. Now that we understand what the role of the written agreement is, let's discuss what is generally in entertainment agreements so that you can understand better when reading agreements what should be in there and what they mean. Now, obviously there are several other terms that are in entertainment agreements, but these are typical ones that you can find in entertainment agreement, and I discuss these so that you can have a better understanding when you read the contracts and what these terms mean. So the first one is the parties. Are the parties an individual? Is it a corporation? Is it an LLC? But the parties need to be laid out to the contract. Next, the roles and responsibilities. This is very important. What will each party be required to do? I always recommend that you be as specific as possible and as thorough as possible as what each party should do and when. Next is consideration. We discussed this before, but here in an entertainment contract, consideration could be back-end points on a film, merchandising, licensing, anything like that is considered consideration. Next, rights. What rights are the parties conveying? This is specifically important for above-the-line agreements. So, for example, you have some A-list client that's going to be in your film. You got to make sure that you get their name and likeness rights, that you be able to show them on the film, and that they allow you to show them in the film. The next is the term. When is this supposed to be done, and how long is it supposed to be done for? Next is the form of a relationship. Is this an employment agreement? Is this an independent contractor agreement? Is this a co-production agreement? What kind of relationship are you addressing in the agreement? Next is called representation and warranties. What each person is acknowledging as true, that they acknowledge that they have the right to enter the agreement, for example. Next is an indemnification. What happens if mistruths come to light? So if you lie in the agreement, this indemnification should help the other person defend themselves in the case of being sued. Next is jurisdiction. What state will have the authority to hear this agreement? Most entertainment contracts have jurisdiction in a state that has experience in entertainment, such as California, New York, etc. So choose a jurisdiction that you think will be better suited in order to hear a case that has entertainment experience. Last is an assignment. This assignment clause is very common in the entertainment agreement and is much needed for the producer because you should be able to have the rights as a producer to assign the agreement so that you will be able to either sell the project or assign the rights for a certain amount of time. And if you don't have the rights to assign the agreement, then you're not going to be able to sometimes get the clearances needed for distribution on a film. Okay, now that we saw all of those items listed out, let's address those so we can get a better understanding of it by using an example. Let's start with the parties. The parties in this example will be Susie Starlet and Super Sleuth Productions. Susie has her own company, which is a corporation, and Super Sleuth is an LLC. There's Susie Starlet and there's Super Sleuth getting ready to make a deal. The roles and responsibilities. Here Susie will serve as the star of Super Sleuth's upcoming movie, The Pitfall. Super Sleuth agrees to employ Susie as an actress. Next is the consideration. Susie will commit her time, and Super Sleuth will pay her $1,500 a day to be an actress in their film. Next is the rights. Again, as I mentioned before, this is very important for the producer, but here Susie needs to agree to grant, and Super Sleuth will own the use of Susie's name, likeness, performance, and image in the movie, so that Super Sleuth will be able to go and say, we own the rights to show her in the film and be able to then sell the film. Next is the term. The date of the agreement in this example is, say, the 1st of next month, and Susie agrees to work for 20 days and do an additional 8 days of publicity. Here I would go even further if I was negotiating and ask whether those 20 days are either consecutive or non-consecutive, and even maybe flesh out whether those 8 days of publicity include travel or they do not include travel. Next is the form of relationship. Here Super Sleuth will be Susie's employer. Okay, next is representation and warranties. Susie has the capacity to enter into the agreement and sign on behalf of her loan-out corporation. Super Sleuth Productions has the authority and ability to fill its obligations under the agreement as well. Indemnification. If Susie or Super Sleuth gives mistruths in this agreement and one of the parties is sued based on those mistruths, then the non-offending party will be defended by the offending party. All right, the jurisdiction. Susie lives in California and say the movie is going to be filmed there, then we would recommend here at Entertainment Law Partners that the jurisdiction be in California. Next, Super Sleuth has the right to assign the rights contained in the agreement to another party. I've mentioned this before. Assignment is very important so that when the project is ready to be sold, that they are able to say as the producer, I have the rights to give these rights to you now. Now, of course, on the other hand, Susie cannot assign her rights given the agreement is of personal nature. She can assign somebody else to be an actress in the movie. Now, by this example, this just shows you a general way on how to understand these different clauses and how they impact you when reading them. Who really even needs a contract? Well, of course, I always recommend that anybody and everybody who has any expectation of an exchange for their services, even the smallest thing, should have an agreement, even if it's a one-pager. It's better to have something in writing than nothing and then an argument about what people understood as being the deal. This even applies to you yourself. You should make an agreement with yourself with the production on what you will do. If you're the producer, you need to have a producer's agreement. If you're a director and a writer, you need to have a director agreement and a writer agreement so that all the terms and roles and responsibilities of your project are clearly laid out, and there is an expectation of what needs to be done, and it's all laid out in paperwork that you can use later on if need be as proof or a defense or an enforceability issue. So again, as a lawyer, of course I recommend that everybody have a contract, but what you don't know and what you should know is that even yourself, even if you own the project, you should have an agreement with the entity that owns the project as well. Okay, well, we've come to the end of the webinar. I really hope that you got a better grasp of the entertainment law contract and how to avoid the pitfalls of those dreaded handshake deals. If you want an invite to the next webinar, email us there at that website. If you have any suggestions or topics that you'd like us to address or even some quick questions, email us there as well. We also have some great information on our website and also on our Facebook page where we're constantly updating and educating our clients and colleagues and anybody interested in the entertainment field. So again, thank you. I hope you enjoyed it and have a great day.